We're ready, Your Honor.
Okay, thanks. Welcome to the Office of Tax Appeals. I want to thank everyone for attending today. My name is Josh Lambert, and I'm the lead administrative law judge for this hearing. My co-panelists today are Kenneth Gast and Stephen Kim. All three of us will meet after the hearing and produce the written opinion as equal participants. Before we go on the record, I want to discuss a couple of things. The Office of Tax Appeals is not a court, but an independent appeals body. The office is staffed by tax experts and is independent of the state's tax agencies. Also present is our stenographer, Ms. Alonzo, who is reporting this hearing verbatim. To ensure that we have an accurate record, we ask that everyone speaks one at a time and that they do not speak over each other. Please speak directly into the microphone and mute your microphone if you are not speaking. Also, please speak loudly and clearly. When needed, Ms. Alonzo or the panel will stop the hearing process and ask for clarification. After the hearing, Ms. Alonzo will produce the official hearing transcript, which will be available on the Office of Tax Appeals website. And before we proceed, could we do just a microphone check? Mr. Schamberg, you just press the button and speak into it.
Good morning. Thank you for hearing the case, judges.
Thanks. And you have someone with you will she?
Yes, she will not be testifying. She's here for my support.
Okay, thank you. And FTB, could we test your microphones?
Yes, good morning.
Good morning.
Thanks. And Ms. Alonzo, are you ready to proceed?
Yes, sir.
Okay. We are now on the record in the Office of Tax Appeals oral hearing for the appeal of McDonell Lane, Inc., case number 240115255. The date is March 12th, 2025, and the time is 9:37 a.m. My name is Josh Lambert, and I am the lead administrative law judge for this hearing, and my co-panelists today are Judge Gast and Judge Kim. FTB, can you please introduce yourselves for the record by stating your names?
My name is Topher Tuttle.
Jackie Zumaida.
Thank you. And for the appellant, could you please introduce yourself for the record by stating your name?
Brock Schamberg.
Thank you. Thanks everyone for attending. The issues today are whether appellant was doing business in California for the taxable year ending December 31st, 2020, whether appellant established a basis to abate the late filing penalty, whether appellant established a basis to abate the demand penalty, whether the filing enforcement cost recovery fee is abated, and whether interest is abated. FTB provided exhibits A through H, and appellant provides exhibits 1 through 12. Exhibit 8 was a web link, and no PDF was provided, which I discussed in the minutes and orders, so I'm not going to include that as an exhibit. And I added exhibit 12 to the minutes and orders, which are attachments to appellant's opening brief, just to be sure that all the documents that you submitted are included as exhibits. So these renumbered exhibits are 1 through 12. FTB, were there any objections to appellant's exhibits?
No objections.
And Mr. Schamberg, are there any objections to FTB exhibits?
Thank you. I have no objections to the exhibits. I do have concern that there are exhibits and information that post-date December 31st, 2020. When I first got the letters from the taxing authority, I answered them with all the information, but that information was current at a much later date. So I would request, Your Honors, that you would, in reviewing any of this information, take into account that we are, I'm sorry, very nervous, that you would take into account that things changed after December 31st, 2020, and that Thank you very much. And that exhibits that might be there, I have no objection to them, but that the relevancy, I do object that the relevancy has only to do with the issue at hand, which is the tax year 2020.
Yes, we will definitely take into account the relevant facts as to the tax year, and we'll be aware of any documents that are dated later where the date of it is procedural, because it's just a notice sent after the fact, and you could make clarifications if you want during your presentation of anything we should be, we should look to.
Thank you, sir.
Okay, so that evidence is now on the record. Mr. Schamberg, this will be your opportunity to explain your position, and you have 20 minutes, and I can swear you in before your presentation, and you don't have to stand. Okay. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, thank you, Mr. Schamberg, and you can proceed when you're ready.
Thank you. I'm not sure whether to begin with information that's already been submitted to you or ask the panel if you have any questions based on what you've seen. I don't know the procedures, but I'm certainly willing to begin by answering questions.
Mr. Schamberg, you can just provide your presentation,
All right.
and after that, then FTV and the panel can ask you questions.
Thank you. This is a very simple case. And it's simple because throughout the year 2020, there were absolutely no business done by McDonell Lane. How is that possible? It's possible because the payments, when McDonell Lane sold the piece of property that it owned and set up the payment schedule, all was to be handled automatically. Payments were made by the debtor to an escrow company. The escrow company then sent it to an international banking operation. The international banking operation accumulated those funds, and at some time during the year, because this is a subchapter S corporation, the other partners and I would make a decision whether or not to actually distribute funds or not. There was no transactions outside of that other than paying internal bills during that year. Now, the other partner, that it was a 50% owner, died unexpectedly in November. I don't remember the exact date. In November of 2020, no distributions had been made. No additional business was conducted. And when I say no transactions for profit or gain were made, other than perhaps internally, I think there may have been some interest that came into the account, but no additional funds went in, no other transactions. When the other partner died, we had already moved to California. And let me be perfectly clear. I always paid my federal and income and state California income tax. Even during 2020, even though there was no distribution to us from McDonell Lane, although we were entitled to it, we didn't. The other partner and I just didn't. There was no question. We never even discussed whether there would be a distribution, because she didn't survive till the end of the year. But what I'm saying is, even though there was no distribution, because it's a subchapter S corporation, we are taxable. And so Mr. Tuttle's, I think it's Mr. Tuttle's office, but anyway, the taxing authority had all of that information because I declared my share of the income, and it was on, I say our, because it was my wife and I. We declared the income on our California income tax return, and we, of course, paid our California taxes. So when she died, she was the treasurer. She was the operating person because she was living in Alaska. Everything was done. That was the mailing address. There was no office. The business had shut down and there was no office. All there was a mailing address. That was her mailing address. When she died, unexpectedly, we had to do something. So in December, about December 15th, I changed the address to my address, McDonell Lane, care of. It wasn't McDonell Lane's new address, it was in care of me. And that means, of course, that it is not a regular address of the company. The domicile, as opposed to the state's position, is Alaska. The funds are in Alaska. The single piece of property is in Alaska. The accountant is in Alaska. The records, the financial records are all in Alaska. The only records that I had were the corporate book. Anything I did was strictly internal work of the company. There were no business transactions. So, she dies. I changed the address so I could get the tax return done. It was prepared in Alaska. My address, care of Brock Schamberg. All right. Until we could settle her, get her estate settled, and perhaps we would have another address in Alaska. But as it turns out, after all of the problems of her estate, it was her daughter who lives in Washington that became the primary heir and took this asset. So we have an interstate problem as well. We have an Alaska situation, funds, domicile in Alaska, banking, international company, and distributions would be made after after 2020 to both Washington and to us here in California. So there's really a legal question here as to the Commerce Clause, the international operation that this very tiny little company, one asset, one corporation, no tax structure of any kind of loopholes or anything like that. I lost my train of thought. So we've got a question as to the Commerce Clause and international taxing, the restrictive taxing of a something in international, national commerce. So that's the situation. I changed the address, care of me, did the tax return, signed the tax return with my address. Now there's another question. This may sound a strict construction. If this is a penalty situation, and I realize you're going to be considering a penalty situation, nowhere in this statute does it say I have to file, or nor was I told by the taxing authority that I had to file a California tax return for McDonell Lane. What I sent him was the Alaska tax return for the corporation, and of course he had the federal tax return already. The same information in the Alaska tax return and the federal would have been the same thing in a California return. There's nothing different. He had all of this information. It's duplicitous to ask that we would to then file this and penalize us because I didn't understand that they were asking for a California return. The statute says to file a tax return. That's what it doesn't say, file a California tax return. Excuse me. Let me talk about domicile for just a minute. I think it was the Bass case in 1987 somebody told me about, where working on the internal structure and finances of a corporation is not, quote unquote, doing business. That's taking care of the internal work of the company. I wrote a check I wrote a check to the accountant. Yes, I am the signator on that check for preparing the tax return. I think I also, during that tax year, I think my partner perhaps reimbursed herself for the post office expense. There may be one other thing that I'm not thinking about. Oh, I think it was reimburse the snowplow so they could get to the P.O. box. That's all that was done. Nobody bought anything. Nobody sold anything. The money went in. I guess I was told that this is a passive situation, that it's totally passive. And when we're talking about domicile, everything was done in Alaska up until she died in late November. 11 months. The address was changed in care of me for 2 weeks in 2020. I think I quoted a couple of statutes that I found that it says foreign corporations shall not be considered to transact interstate business by holding board meetings, okay, or carrying on other activities. I think that's under Chapter 1, Sub C, and other activities of its internal affairs. That's my role. That's what I was doing. If we're going to look at that 2 weeks as being domiciled here, or the domicile, I think it's important to also say you can't have just domiciliary issues without also some kind of it's commercial domicile. And the commercial domicile is still in Alaska. That's where all the transactions happen. There was no transactions happening here except for except signing that tax return. So this is a very simple case with a very, very tight 2-week period. And I've been told that the issue that you can have one financial transaction and that's enough to then become subject to it, to the taxing authority. There wasn't one. Not a single transaction. All passive, all in Alaska. No distribution of funds, okay, to me even here. And so actually let me point out, there were no distributions of any kind until 2022, I believe, when the other person became, anyway, there were no distributions in 2020, but yet I declared it on my taxes and I paid them. So there was the domiciliary issue requires I saw some kind of a note that, let me see if I can find it. I can't remember if it was which particular case it was at this moment, but it pointed out that you cannot have a commercial domiciliary without a commercial activity. It doesn't happen, and that is it was mentioned in a Supreme Court case. All right. So it seems to me after reading the statutes that foreign corporations can do a lot here without being subject to a tax. They can have a bank account. They can have an office as long as they're not soliciting sales. They can do other aspects without qualifying to do business here. There's no office here. We don't maintain an office for McDonell Lane. I maintain the corporate book. The only thing I do is the internal work. And I only did it possibly, what did I do? I didn't write a check until 2000 for the tax return was not written in 2020. It was subsequent. So the interstate aspect of this really becomes a burden, having to require, because California is already getting the tax from our share, but now it also wants to tax the other person's share by requiring McDonell Lane to do business. That is a burden on interstate commerce. They live in Washington. But she didn't in 2020. Everything was simply Alaska and California at that time. There's a class action pending that I understand that this case might be a member of that class. Do I need to reference that? I believe it's the Ball versus Cal FTB, case number CGC 16554150. And I believe that I was told that there is a class action order in that case that defines the class. I have not seen it, but my understanding is that this case may fall under that class. One of the other things that I noticed in the statutes is that holding a mortgage on California property can be done by certain companies without requiring them to do business here. So if holding a mortgage is excluded here, why isn't it possibly excluded if it's an Alaska mortgage and everything is done out of state? Give me a moment, please, to review. Oh, and I think, excuse me, if I wasn't clear, the passive movement of those funds is done without any operation of anybody in the corporation. It is all done automatic. It was set up in 2019. Nobody does anything. It moves totally under the written instructions that were made in 2019. The only thing that would have been done in 2020 is a distribution of those funds between the partners in the subchapter S corporation, and that was not done. No distribution. But as I mentioned many times, taxes were paid. And the Alaska tax return was filed, and the federal tax return was filed. And the taxing authority had both of those. So as again I was saying, filing any kind of a California return for McDonell Lane would have simply been duplicitous in terms of the information it provided. And what's the purpose of the return? To see if it's taxable, to see if there's taxable income. Well, California did have all of that. When mail is sent to someone in care of someone, it means that the mail is being sent to an address where the intended recipient does not normally receive mail. That was the postal definition that I had looked up. There's also the issue of that this is a tax, and the issue of whether or not California can fairly reach that economic activity in Alaska, where there is really no benefit to the corporate. Excuse me. There's really no benefit to the foreign corporation for requiring it to register. There's no economic benefit whatsoever, and it's also duplicitous. By the way, there's no wages of any kind that are paid by this corporation. There were none in 2020. There are none. So the purpose of filing a California tax return was to compute the tax amount under the RNTC Section 23251. And the federal tax and the state taxing authority had the information. So it was inconsequential and punitive in nature to require for us to be penalized now for not filing it, especially as I pointed out when the statute itself, it never mentions California tax return, it just says tax return.
Mr. Schamberg, I think your time is almost up, so if you want,
Alrighty.
you could
Let me-
finish.
Thanks, I will. Thank you. Here it is. Judge Cheng's order in October of 24 in that case denied summary judgment in the Ball Media case. It says due process requires some definite link, some minimum connection, some property, a transaction before it can tax. And finally, Article 1 in the definitions and general provisions provide that doing business means a financial for pecuniary gain, as the board and the judges are fully aware. Thank you.
Thank you, Mr. Schamberg. I will turn to FTB. Mr. Tuttle, did you have any questions for Mr. Schamberg?
No questions.
Okay, thanks. I'll ask the panel if they have any questions. Judge Gast, do you have any questions?
This is Judge Gass. I don't have any questions at this time. Thank you.
Thank you, Your Honor.
Judge.
I don't have any questions at this time.
Okay, thank you, Judge Kim. I had some questions that I wanted to ask you.
Thank you, sir.
I just wanted to clarify some facts. So I believe it was stated there were Zoom meetings that occurred during 2020. Is that true?
I'm sorry. Let me think for a minute.
In one of your briefs, you said that having a Zoom meeting does not count as doing business. So I was clarifying if there were any Zoom meetings that happened.
I do not remember that back that far. I don't remember any Zoom meetings. It does not mean that they could not have happened. However, if there was a meeting, it would have, in 2020, it would have either been with the deceased partner or their attorney, or the estate attorneys, or the accountant. No Zoom meeting would have happened with regard to any financial transaction other than something internally for the corporation, such as did the estate need any documents that they couldn't find in Mary's files, because she had everything. In fact, it had to be sent to me subsequently, or it may have been the accountant who needed information that I would have gotten or had directed from the mortgage company, because it wouldn't have been sent. But anything that would have happened, I can honestly testify to the fact, one, I don't remember, but two, if it was, it would have only been internal workings. Nothing, because nothing external ever happened.
Okay, thanks. And after the other shareholder passed away, her trust took over her ownership percentage. And I was wondering, the trust and the trustees, like how much control or management they asserted after she passed away. Did they contribute in terms of, any responsibility in terms of managing?
At that time, I was the minority shareholder. I was the minority shareholder. Subsequently, we have created a trust. She was 50%. She was the controlling shareholder. And yes, we did whatever she wanted done. If she wanted a distribution, we'd do the distribution. I never remember any discussion about doing any additional business outside of the funds that were coming in automatically. So the answer is yes, she was the 50% shareholder at that time.
Okay. Okay, thanks. And you were the minority shareholder, but then there's a Miss Schamberg that was also a shareholder too, right?
That's correct.
Okay. And was Ms. Shire was she a director prior to
Yes.
passing away?
I mean, I don't have the documents in front of me, but my understanding is that she was a director, she was a shareholder, and she was the treasurer at that time. And she was the signator. She is the person who signed the checks. And actually, my recollection is, I won't say she signed all of them, but I think she was the only one. And I think she signed the tax returns, but I'm not positive about that.
Okay, thanks. And on the tax return for McDonell Lane, it states there was an installment sale payments. Was that related to the property that was sold?
That was the only thing, yes, sir. That was the installment sale done in 2019 with payments coming in automatically each month.
Okay, and there was a payment made on December 31st, 2020. And so these payments, they went to an account in Alaska, and
Well, it's an international company, but yes, the office
Okay.
that we had set it up with was in Alaska.
Okay.
It has an Alaska number, and that's Alaska Mortgage Company collected it, sent it on to the Alaska account.
Okay, and some payments, it looked like they flowed through some payments flowed through to your K1s. It looked like there was some 1231 and 1250 gain.
Correct. They flowed through to us without any distribution.
Okay.
So we received no funds, but they flowed through tax-wise.
Okay. And on the McDonell Lane tax return, and on your K1, there's interest and dividends. Were those from separate accounts? Because on McDonell Lane, it looks like there was different types of accounts, maybe.
No, sir. There's my recollection, and yeah, I'm almost positive. There's one bank account during 2020. Was there before? There may have been another account in prior years. I don't remember how she did it. But in 2020, there's one account. Funds flowed from that sale, that installment sale, into that account. There may have been interest and dividends from positions held in that one account.
Okay. And
she may have made she may have moved some funds in the account from one interest bearing to another, but it would have taken, it all would have been internal. It would not have been from source outside, because to my knowledge, there was never any other source.
okay, thanks. And was the purpose of the corporation what was the purpose of the corporation? Was it to just sell that property and then receive money into the trust?
Right. The purpose of the corporation originally was to hold that property. It was a rental. It had a couple of buildings on it. One, I think, was I guess you could call it a house. Anyway, it had a couple of buildings, and it was rented. And it was held for many years. I don't remember the original. I think it probably tells in the tax return what the original date was. But for many years. It was decided in about 2017, I think, to go ahead and sell it off. Took a while. maybe in 2018, I don't remember. Anyway, the sale was completed and all the documents signed in, I believe, 2019. So there was no other work, no other business of the corporation. That was the end of it.
So the corporation would just, so you're saying that the activity for the corporation was done and now payments would just be received into the international account?
Right.
On the note.
Right.
And was there like some plan to receive distributions in the future, or
The plan was to let the instructions that were made in 2019 work out completely. So that would have been at the choice of the owner of the buyer, and according whatever the instructions were, the terms, whatever the terms of the note and the mortgage were at that time.
okay?
And
Thank
that
you.
was all done by Alaska attorneys, Alaska counsel.
Okay. Okay, thank you. That's all the questions I have, so
Right.
thank you, appreciate it.
Of course.
Now, we can move on to FDB's presentation for 10 minutes. So, Mr. Tuttle, you can proceed when you're ready.
Thank you. Good morning. My name is Topher Tuttle. I'm representing the Franchise Tax Board, or FTB. With me is Jackie Zumaida, also representing FTB. The issues in this appeal are whether appellant owes the minimum franchise tax and whether appellant has established a basis to abate the delinquent filing penalty, the demand penalty, the filing enforcement fee, or interest. The facts of the case are simple. After appellant's Alaska-based shareholder, who was also a corporate officer, passed away during tax year 2020, management fell to the remaining two shareholders who were located in California. FTB's proposed assessment for tax year 2020 is based on appellant's California activities. First, I will discuss whether appellant owes the minimum franchise tax. If a corporation is doing business in California, as described in Revenue and Taxation Code Section 23101, it must pay at least the $800 minimum franchise tax to California and file a California tax return. In the Presidential Office of Tax Appeal opinion, Appeal of GEF Operating Incorporated, the panel found that Section 23101 included two alternative tests to determine whether a taxpayer is doing business in California. The first test is found in subsection A and states a taxpayer is doing business if it is actively engaging in any transaction for the purpose of financial or pecuniary gain or profit in California. The second test is found in subsection B and includes a list of specific conditions which, if satisfied, will establish a taxpayer is doing business in California. Appeal of GEF specifically states that these conditions are not minimum thresholds and do not provide any safe harbor from the general definition of doing business found in subsection A. In fact, the Office of Tax Appeals found that subsection B was intended to broaden the scope of doing business to explicitly encompass owners of pass-through entities with economic presence in California. FTB agrees that appellant does not appear to satisfy any of the conditions in subsection B for doing business. However, this does not prevent FTB from finding appellant is doing business under subsection A. In this case, FTB received information that appellant used a California address on its federal tax return. Appellant has confirmed that its corporate address was changed on December 15, 2020, from an address in Alaska to an address in California. Therefore, appellant actively engaged in a transaction in California by changing its corporate address for the convenience of its managing officers and shareholders. Since appellant remains an active corporation, appellant's change of address was for the purpose of financial or pecuniary gain or profit. Appellant continues to receive an income stream related to the sale of its real estate asset, and appellant's California shareholders managed appellant's business from California after the managing shareholder in Alaska passed away. Thus, appellant was doing business in California and must pay the minimum California franchise tax. Next, I will discuss whether appellant has established a basis to abate the late filing penalty and the demand penalty. Both the late filing and demand penalties were properly imposed because appellant failed to timely file a tax return by the due date and failed to do so upon notice and demand by FTB. Appellant has not alleged error in the imposition or calculation of the penalties, only that it did not have a filing requirement. Even if a taxpayer is unaware of a filing requirement, ignorance of the law is not an excuse for failing to file a timely return or failing to file a return upon notice and demand. As such, appellant has not established reasonable cause to abate either the late filing penalty or the demand penalty. Next, I will discuss the filing enforcement fee. FTB notified appellant it had a filing requirement, and appellant failed to file a return by the prescribed due date. As such, FTB properly imposed the filing enforcement fee. And once the filing enforcement fee is properly imposed, there is no provision that excuses the imposition of the fee. As such, appellant has failed to establish a basis to abate the filing enforcement fee. Finally, I will discuss interest. If the tax is not paid by the original due date, interest must be charged on the resulting balance due, compounded daily. Interest is also charged on penalties if they are not paid within 15 days of notice and demand. Interest is not a penalty, but is merely compensation for a taxpayer's use of money after it should have been paid to the state. There is no reasonable cause exception to the imposition of interest. In this case, appellant has not established that any of the limited exceptions for abating interest applies. Furthermore, FTB's review of this matter shows no irregularities in the processing or treatment of this case such that an abatement of interest is warranted under the law. Therefore, FTB properly charged the mandatory interest, and appellant has not established any entitlement to its abatement. In conclusion, appellant has a filing requirement because it was doing business in California during tax year 2020. In addition, appellant has failed to establish a basis to abate the delinquency penalty, the delinquent filing penalty, the demand penalty, the filing enforcement fee, and interest. Therefore, based on the facts and evidence in the record, FTB respectfully requests you sustain its position. I'm happy to address any questions you may have. Thank you.
Thank you, Mr. Toto. I will turn to the panel to see if there's any questions. Judge Gast, do you have any questions?
Yeah, I have a few questions. So you said that FTB doesn't contest doing business under 23101B, is that correct?
That is correct.
Okay, so commercial domicile was in Alaska in 2020 under B1?
That's a good question. And that's not something that we have briefed, and that if the panel is interested, FTB is interested in briefing it post-hearing.
Okay, thank you. And then your position is basically that the taxpayer was doing business in California because of a shareholder controlling the company in 2020?
Right. So the California shareholders were also corporate officers, and so their activities, their management of the business of the corporation are the activities that FTB asserts rise to the level of doing business.
Okay. And then in that same kind of vein, Regulation 23101, which appellant cited in its brief, B says the mere receipt of dividends and interest by a corporation and the distribution of such income to its shareholders does not constitute doing business. Is that any different from what happened here?
So I would argue that the taxpayers' use of California address to conduct business is more than the passive receipt of income.
Okay. And what was the business? Because the corporation, the S corporation, sold its only asset the year before and seemed to be just collecting interest on the sale. So in your view, what was the business after that?
Yeah, so the existence of the corporation and its continued receipt of the funds relating to the sale of its sole asset is its ongoing business, is its very existence. And the minimum franchise tax is imposed on corporations for their existence and active receipt of those funds related to the transaction, that had previously occurred, but it's the business of the corporation holding an address, filing tax returns. That remains an essential part of its function to obtain that income stream. And for it to continue to be a valid entity, it must jump through the procedural hoops of maintaining an active address where it can receive service of process, filing tax returns. It still exists as an entity, and so those activities of managing its existence and continued receipt of those funds rises to the level of doing business under 23101A.
Thank you. Sorry, just one more question here. Regulation 23101A does say that doing business occurs when the company has liquidating activities consisting of collections on notes. And then B then says, mere receipt of interest. Do you know what the difference is between collection on notes versus the mere receipt of interest?
That's something FTB has not briefed and would be willing to brief post-hearing. Thank you.
Okay, no problem. Thank you very much.
Thank you. Judge Kim, did you have any questions?
I think my questions have been answered. Thank you.
Okay, thanks. And the brief for FTB did mention 23101B, the commercial domiciles, so it was briefed briefly. So would you say it's still at issue for FTB?
Yes, and I may have misspoke earlier in my presentation when I discounted its applicability to. In my mind, when I made that argument, I was referring to the thresholds for economic nexus rather than the commercial domicile prong of that analysis.
Okay, thanks. I don't have any further questions. Actually, Judge Gast may have a question.
Yeah, I'm sorry. This one is for appellant, Mr. Schamberg.
Yes, sir.
Can you touch on again in 2020 what kind of control, if any, you exerted and your wife? I know that you said about 25%. She had about 25%, so that's about 50%. So yeah. The other shareholder also had 50%. So it seems equal there. Can you touch on because we don't have, the agreement of the operating agreement of the LLC or the S corporation and file. So can you touch on who had control over the entity during that year?
Interesting.
And after she the other shareholder passed away.
Thank you. There is no operating agreement. There never was an operating agreement as such. These are two people who lived basically a couple of doors away from each other that bought a piece of land and decided to buy a piece of land and rent it, and that's the way it went for 15 years or whatever the amount of time was. So no operating agreement. Everything was done by consensus. I was, as I said, was the minority shareholder. My wife was 25%. Mary had 50% until I guess it wasn't a trust at that time, but anyway, she was the controller. What control did we have? All I can tell you is we never what's the word I want? We never manifested control. We never did anything without total agreement between Mary, my wife, and I. We would not so much as buy lunch unless we were all together and paid for it that way. This was just a little small situation where we had that piece of property. So we can, whether we had 50% together or not, we never, ever did anything separately from working with Mary. Mary she was the boss, you know. And I mean, she never ruled over us, but it was, you know, she had an idea, she'd bring it to us and we'd do it. And if we had an idea, we'd talk with her. Does that answer the question? I'm sorry.
Yeah.
Okay.
And then one more quick question. I'm sorry. When the property was sold in 2019, after that, the whole purpose of the company or any activities you did in California was limited to winding up the business. Total business.
Total.
And
Whether I was in, and I was going back and forth. I was still in. I can't remember, but yeah. Anything we did after 2019 was literally, that's why it was sold, winding up the business, trying to get an income stream to support Mary and us.
Thank you very much. I don't have any more questions.
Thank you.
I just wanted to follow up on just one thing that Judge Gast was saying about how much control was exerted on each side. And you were discussing before the other shareholder passed away, but after she passed away in December, was the situation the same in terms of control with you and Ms. Schamberg and the co-trustees in the trust?
Our percentages of ownership had not changed. Everybody was in such shock. I can tell you that from the time Mary died until the end of that year, nothing was done other than trying to determine her heirs and the whole legal issue about, you know, what was going to happen. We certainly would never have done anything, nor probably could we, that would have been in contravention of that situation. We didn't take any kind of distribution, and the trust did not ask for one.
Okay, thank you. So, Mr. Schamberg, you can make your closing remarks now for 10 minutes.
Thank you. Listening to counsel, it was an interesting argument, and one I wasn't aware of, that continuation of the corporation is in fact kind of like doing business, and therefore we should register. But that's not what happened in 2020. In 2020, there was no business other than it's already been explained many times about the internal work. Now, the address is not necessary for service of process. The registered agent of the corporation resides in, lives in, and is not just a corporation. I mean, I'm not a hired gun. I mean, the registered agent lives in Alaska, still there. It's still the registered agent. Russ Minkelman was the accountant. He's the registered agent for service of process. I use the address here because something has to come to me so I can pay my personal California income tax. So the tax return, federal has to be done, and I have to pay my California tax, which I've always done. I want to point out that one case that I mentioned, which is Complete Auto Transit versus Brady, 430 United States 274, 1977. And basically, the case says non-existent activity cannot have substantial nexus to California. The first prong of the complete auto test is that there must be some actual financial activity that is not simply internal. California Corporation Code 191, I think that's a 2024, says, without excluding other activities that may not constitute transacting business, that holding meetings of its board of shareholders or carrying on other activities concerning its internal affairs, that's sub 2, is not transacting business. Number 7, engaging in activities necessary or appropriate to carry out any of the foregoing activities is permitted. It's not conducting business, even though I live here and there's an address here. Thank you very much, gentlemen.
Thank you. I'll ask my co-panelists if they have any final questions of either party. Judge Gast, do you have any questions? No questions. Okay, Judge Kim, did you have any questions?
No questions. Thank you.
Okay, thanks. If there's nothing further, I'm going to conclude the hearing. I want to thank both parties for appearing today. We will issue a written opinion with 100 days. Thank you. The record is now closed. And the next hearing will be at 1 p.m. Thanks.
Thank you.